We're thrilled to have Judge O'Malley with us. We've been a fan of hers for a long time here at the center and have been hoping to have an opportunity to chat with her about her distinguished career. And so, as many of you know, probably everyone knows, that she has been on the federal circuit for many years now, was appointed by President Obama, and before that was in the Northern District of Ohio. And so I just realized all your Ohio connections. I guess I didn't realize that before. Case Western for law school. And then other time, Judge Braden's a fan there. I actually have a tiny connection, which is I was born in Cleveland.
Really?
But we're only there for 2 years. So, but it's forever on my passport. You from Ohio? No, I'm not. But and then you're at Jones Day and had just a long and distinguished career. And so what we want to talk to you about today, now that you're getting at the end of your time on the bench, and we're very excited to hear about what your next chapter will be. So I want to kick it off by just asking you to tell us a little bit about your time on the federal circuit and some of the changes you've seen on that, and just kind of a reflection on your career to date.
Well, thank you. First, I want to say I'm not sitting on the edge of my seat because I'm nervous. I'm sitting on the edge of my seat because my legs are so short that when I tried to sit down, I fell back into the chair. So. It's been an interesting road for me. It's all I ever wanted to do was to be on the federal bench. I decided that when I was about 13, believe it or not. I read the book Gideon's Trumpet, and I decided at that point that federal judges can do a lot of important stuff, and there's some interesting things that go on behind the scenes, and so I wanted to become a federal judge. And shockingly, despite a lot of mistakes that I made along the way, it happened. So I was on the district court for 16 years. It was really an interesting time. I mean, the district court position is intense. I mean, you're just constantly wondering what's going to come through the door and what's going to happen next. And I went through, being from Ohio, there was a lot of corruption in Ohio. So I went through a series of, as my brother put it, putting different communities, the top people in different communities in jail, and then we move on to the next community. So we did a lot of public corruption, did some mob cases, did a lot of civil rights work, did a lot of MDLs. So it was quite a time. And when the opportunity to go to the federal circuit came along, I wasn't sure that I would like the idea, despite how interested I was in IP. But there were a lot of reasons, including personal ones, that made sense for me to come to DC. And once I did, I was thrilled because there is something to be said for getting to delve into topics in a lot more depth than you get to do as a district court judge. You're not bouncing from thing to thing. You're actually focusing on things and interacting with your colleagues. It was a big deal not to have my own courtroom anymore and to have to at least get one other vote for everything I wanted to do. But once you get used to that part, I really did enjoy it. And I know a lot of people are surprised that I'm leaving when I am, but I feel like I've got another chapter left and I need to figure out what it is. Yeah. So
tell us a little bit about how you pivoted to IP. I mean, obviously the federal circuit does a lot more than just intellectual property. But you clearly delved in with both feet into IP. Were you doing many IP cases in the Northern District before, or when did this come about?
This is actually kind of a funny story. Originally, when I first went to Jones Day, I was put on IP cases. I was doing the old Lubrizol Exxon cases. For you, the old timers will remember those. And Jones Day was one of the first big firm that was doing IP litigation. And I said, I don't really want to do this stuff. I don't have a science background. And they said, well, we need somebody who can write. And the science people, you just write, and you call it gunk or gunk plus 1 or gunk plus 2, and we'll put the formulas in, and it'll all work together. So I finally, at some point, went down to the head of litigation. I said, really, I want to be a judge someday. And I swear I said this IP stuff is not going to get me there. And
there's no future in it.
And so I said, I need to do more things. I need to get a reputation of actually trying a case in my own city, as opposed to going all over the country being the 6th person down on a huge case. And they said, no, that this guy, Hal Cooper, was good at what he did, and if he wanted me, he got me. And so I said, I'm leaving. And I did, and I left and did very little IP after that. But then, I take that back. I did trademark and copyright, but I did very little patent work after that. So then I went back as a judge, back to Cleveland as a judge, and in order to create the new docket for the new judge, everyone was allowed to give up a number of cases. And so I got to the Northern District of Ohio, and I received, I kid you not, every single patent case on the docket. Every single judge sent all their patent cases to me, and some of them were years old. And then after I took the bench and I said, well, look, there's a couple more openings coming along. And I told my law clerks, don't worry about it, I'll just pass them on. And then they changed the rules that you couldn't pass on a case that had already been passed on anymore, and you couldn't pass on a case that was older than 2 years old. So I was stuck with all of those patent cases. And I thought, well, I got to do it. I got to dig in. So I started to learn it again. I got so involved in it that I ended up teaching it at Case Law School and doing a lot of programs around the country. And so I became known as not so much a person who loved IP, but a person who didn't hate it, who didn't hate patent cases. And so that's where the hook came from. And then when there was a desire to put a district court judge on the federal circuit, I was one of the logical candidates.
It was the hand of fate.
Right.
Kept coming at you, and you finally went with the flow.
I know. It's very.
Don't fight it anymore.
Because both my parents were scientists, and I kept trying to run away from what they did. I thought I would be better off talking my way through life, but so they're probably looking down on me laughing right now. But.
And so then from Kenyon, which is where you went for undergraduate, so no science degree.
No science degree.
What was your major?
My major, I was a double major in economics and honors history. Yeah. I wanted to be a history major. My father said, if I'm paying the tuition, you have to be something that's useful. So he said economics would work. So I could have just picked the economics, but I was stubborn, so I did double major.
Now, at the same time, there's often, and this is a bit more to law students and people wanting to go to law school, sometimes there's misinformation that if you're going to be a patent attorney or do IP as an attorney, you have to have that tech background. But of course, we all know that really is primarily for prosecution. And so tell me a little bit your view on that often people without a science background can be better communicators about IP and the tech because they have to internalize it in a way that's not just the formulas the way an engineer would approach it, but isn't that better in some ways when you're talking to lay people that might be, say, on a jury?
Well, at about the time I came on the federal bench, it was a huge opportunity for the non-tech litigators to get into the patent field. Most of the litigation was being done by patent prosecution firms, and they didn't really know what they were doing. They didn't know how to convey to the jury the information, and just the information the jury needed to hear. I mean, sometimes I would say to the lawyers during a break, I'd say, you're so smart, and you know so much about this technology, but the jury doesn't need to know either all of what you know or how smart you are. They just need to have the information they need to make the decision. And so then it was about that time that a lot of the other firms were bringing their real trial lawyers in and saying, can you repurpose into this field because we think it's going to be lucrative? And so there are a whole host of litigators who are now probably in their 60s and 70s who really started out as litigators and repurposed into the patent field. We're now seeing more scientists who are repurposing to be litigators, but at the time it was the opposite.
And then what do you think, and this may be difficult because you're still on the bench, but what do you think is really the Federal Circuit's primary job? And we know it was created by statute in the early 80s, and there's been some different takes on what it really is supposed to be doing in the field of patent law. What's your view?
Yeah, it's funny because I know in the beginning, the Federal Circuit, those on the Federal Circuit really believed they had this mandate to make uniform rules and to set some clear standards. But the problem is that it was an Article III court. Congress specifically didn't want it to be a specialized court, and so it was supposed to be bound by all the same rules of civil procedure and jurisdiction. And they had to answer the Supreme Court, who doesn't like hard and fast rules. They don't like clear tests. They like 7-part things that apply to any set of facts. And so I think that the Federal Circuit, by trying so hard to do what they thought its congressional mandate was, got themselves in trouble with the Supreme Court. And then the Supreme Court tried to make things so vague that it became difficult for the Federal Circuit to operate within those vague boundaries and still give the stakeholders what they really wanted, which is to know what rules they have to follow and what their chances are with respect to any patent or any particular product. So I do think that their role is to at least have a uniform interpretation of the key principles. And I think, we try really hard to do that. As you know, I recently did a copyright case, and I was shocked to see what a mess that the law is, because every circuit has a different approach, and sometimes fundamentally different approaches. And I thought, too bad copyright doesn't go to the Federal Circuit. I know that would never fly, but there is at least a belief that is, while we might get some stuff wrong at the margins, or some people might really disagree with things like 101, I think that at least you can have a sense of of what the boundaries are on the legal principles. I could be wrong. Somebody might disagree with me.
Well, no, I think there's a lot to be said for giving some coherent principles to the district courts. And you're absolutely right, that doesn't happen on the copyright side. And that's why we get what we get there. And it's really all over the place. So let's bring it to a little bit of the theme of the conference with 5G and telecom. And a lot of as you've heard through the sessions we've been having, a lot of the debate is between the innovators and the implementers. And whether there'll be any more convergence between those sets of players, will remain to be seen. But so in your view about the role of intellectual property, what is it doing in innovation, particularly in the 5G space?
Well, I get very worried about the current state of our innovation policy, just broadly, not just in the 5G space. And I think that the problem is that there has been a lot of dialogue, as you have put it, the anti-IP dialogue, that had gained a lot of traction for a lot of time. For instance, the Supreme Court has really, really bought into this patent troll mentality, and a lot of their decisions actually reflect their view that we have to do away with patent trolls at whatever the cost, and doing away with patents equals doing away with patent trolls. At least that's the way I'm reading the Supreme Court decisions. And that dialogue, I think, I was saying that I think we're a little bit preaching to the choir here, but I think that these voices, the voices here, weren't loud enough when they needed to be, and sort of receded some of the territory. I remember when I did that Erickson case and was first talking about SEPs, there was so much out there about holdup and royalty stacking, and at least I was skeptical enough to say, well, if there is, then prove it. You can't just get a jury instruction on those topics if you don't prove that it's really happening. And of course, now we know the proof is the opposite, that it's not really happening, and the holdout is what is happening. But I think that there have been many voices that took over the dialogue without much skepticism of what those voices were, and it's time that we challenge them.
David Teese had some great comments on the last session, and a topic near and dear to my heart, which is actually understanding the business environment. Well, I think to everyone in the room, and obviously Jonathan Barnett's book, is all about this as well. So what do you think judges can do to, in fact, get themselves up to speed on how global business works, supply chains, how products come together? And let's keep it in the 5G telecom space at the moment. Do you think that they should do some kind of extra homework to get up to speed on it? Or is it enough to have the litigants in front of them, and then they become educated for each particular case?
That's a difficult question, because a lot of jurists have different views on what your jurisprudential practices should be. My view is the more you know, the better, as long as you're not doing the kind of independent research that would not be fair to the parties. But reading between the cases, not as it relates to a particular case, but keeping up to speed on what is going on, I think is important. We were told, I was told in a case that ended up settling because it was one of those anti-injunction suits, and it unfortunately never finished the appeal. And I was told that judges couldn't possibly understand FRAND concepts because it's such a business-related practice, and they were fighting over the whole concept of portfolio-based licenses, and that's not fair. There's not enough apportionment. And I finally was somewhere with a lawyer from one of these companies who's, the in-house counsel from one of these companies. This is after the fact. And I said, how do you guys do your licensing? Oh, broad-based portfolio, always. And it was his own lawyers that were saying that is a terrible way to look at it. So I think that the more judges know about the world in which they're judging and the fields in which they're judging, the better.
Yeah. So it's interesting. Legal education, as you know, has been primarily focused on appellate case law. We learned that. And so it tends to be litigation focused. Some of us have tried to bring some more transactional materials into an experiential education, into legal education. But what do you think about, so for judging, would it be helpful to have more judges who have some transactional background? In the sense that a lot of judges are still often drawn from the litigation side of law firms.
I think there are a lot of, I take that back. You're probably right. In the early days, there were a lot, when I say about the time when I came on and before, there were judges who were being pulled out of the transactional side of mostly big firms, big law firms. But it did become sort of the norm that if you hadn't tried cases, you shouldn't be a trial judge. And preferably, if you hadn't been a trial judge, you shouldn't be on the Court of Appeals. Now, that's not held true in the Federal Circuit very much, but that was more the norm in the regional circuits. But I do think that part of it is a lot of transactional lawyers don't have any interest in being judges. They're happy doing the transaction work. That's why they didn't become litigators. Or they're making so much money as transactional lawyers that there's not as much of an interest. But I do think that just experience generally, because someone who tries a lot of business cases and not just patent cases will understand. They work with their transactional lawyers. We used to jokingly say that our transactional lawyers were our pre-litigation lawyers, because we would then have to litigate everything they wrote.
Yeah, no, I mean, as transactional attorney, you should be looking to the future in that way. And what I often teach the students is you need to be assume that you will not be in the room anymore when this gets litigated. Mm-hmm. And that's part of the problem is the lawyers will say, well, I know what the deal means. I know what's supposed to be going on. But you won't be in the room anymore. And the other side, that lawyer won't be in the room anymore.
Right.
So now how do you document this thing in such a way that it will stand up? Let me ask one more question from me, and then I want to open it up to Q&A here. You mentioned before innovation policy, and as you may know, we've rebranded the center to include innovation policy in the name. We think intellectual property is a key part of innovation policy. Not everyone agrees with that, but does the U.S. really have a coherent innovation policy? And if so, where is that lodged in the government function?
The answer is pretty simple. It's no. I think there was a lot of effort under the last administration and some leadership of Andrei Iancu to try to get to that point. He worked well with the DOJ and with U.S. Trade, but I just think that, you should hear the people around the world. They say, okay, wait, you were getting all messed up, especially on these SEP and the, they don't call it antitrust, they call it competition law and IP principles and the intersection. And then you were getting it better, and now you're getting it all messed up again. What are we supposed to think is going to happen in your country? So I think that the only thing that can be done is to try very hard to get a uniform policy that looks at the perspective of all the branches. Even the executive branch is contradicting itself. And so I think it's time that we have some kind of structure or some kind of, think tank group like these who can help coordinate and create a uniform policy.
Because you're absolutely right. It's funny, other countries, when I travel and give talks on tech transfer and thing, they always ask, well, what is the innovation policy of the U.S.? And they think we have a coherent, they think we have like an agency that's doing that. And I often have to, break the bad news that we do not.
No. And
So in some ways, other countries are trying harder than we are.
And then, some agencies try and they buck up against other agencies who are trying to go the opposite way. And so the efforts to coordinate the thinking of the agencies is important, but it has to go deeper. The executive, there are times when the president says stuff that's completely inconsistent with what his agencies are doing.
And the FDA reaching out to the PTO, that was interesting.
Really interesting. I said, how is that going to work? But yeah, that was one of the stranger
Yes, it was.
efforts.
So let me open up to questions from the room, because we only have about a half hour total with the judge, and I've used up about 15 minutes of that. We have Christina, or someone has the microphone. Where did Christina go? Oh, and I think she's coming in on cue. So questions for the judge.
Hi, Judge O'Malley. I'm John Putnam. I'm an economist, actually. And I was heartened to hear that you also told your father that you were going to major in economics because it was practical.
I know. He thought so. I don't know.
It took me 15 years of economics to make it practical. But so I thought maybe you could comment on the state of economics at the Federal Circuit, damages in particular, but just sort of your thinking about two things: the quality of economic testimony that you review, and also the efforts by at least some judges, in particular in the SEP context, to craft their own remedies that are, depending on how you look at it, creative or dangerous. So, but I'm just wondering if you have any thoughts, given that you majored in economics, on the state of play.
Yeah. You'll find it funny, though. Of course, at Kenyon back then, it was all Keynesian economics, right? It's a different world now. But this goes back to the last panel. I think that a lot of the problem that we have with damages law right now stems from the fact that there's no ability to get an injunction. So what happens is that you end up having circumstances where, because you can't get enjoined, and you mostly can't get preliminarily enjoined, by the time you get to the end of the day, whether you call it efficient infringement or predatory infringement, one man's junk is another man's antique, I guess. But whatever you call it, by the time you get to the end of the day, numbers are huge. I mean, if you're really going to look at the full scope of the infringement, and then that scares everybody. So the court says we must be doing something wrong. We must be letting in too much evidence, or we must not be tightening up enough on concepts of apportionment or other analyses. I mean, as an economist, I always thought that if you change the numerator or you change the denominator, you can get apportionment without having to do things like the smallest saleable unit or et cetera, et cetera. You can always do those changes and fix it, but people don't seem to buy that because they think jurors can't understand that pretty basic economic concept. So I think that there has been a bit of an overreaction to the size of the damage awards, not necessarily because the damage awards are unfair, but because just looking at the big numbers makes everybody back up. Having said that, I have to tell you that there has not been, until very recent years, enough focus on the quality of the damages testimony, the economist's testimony. When I did a speech when I was back on the district court to an international program that the Federal Circuit put on, and I was talking about the fact that Federal Circuit just sort of damages was an afterthought. No one ever looked at it. They just accepted whatever the testimony was, and the number came in, and the number was what it was. If there was validity and infringement, damages just sat wherever the jury put it. But that's not the case anymore. And so you see this move where lawyers for a long time didn't bother much with the scope or quality of their damages testimony. They just made it emotional for the jury, and it figured if they got that far, they needed just to pitch to the jury, not to the Court of Appeals or even to the district court post-trial. But then as that changed, I think there was a slow reaction in terms of getting better economists and the principles. I mean, a couple cases that I've said more than once, why do we have tests that say you go through all of these different tests when half of them don't apply to the facts at issue? And so I think that that the lawyers and the economists are getting smarter, and that's why more of the bigger damages awards are standing up.
So it's a great opportunity to be able to ask you a question. When I teach my students the concept of stare decisis, I distinguish between a simple version where higher court X says X and lower court implements X. And then we move on to a more sophisticated version where X might mean X prime or might mean X and might even mean Y. And once you look at it that way, the lower courts have a lot of power in interpreting the decisions of the higher court. So taking that structure to the federal circuit, how do you, in your experience, what role has the federal circuit played in interpreting and implementing some of these fairly loosely defined principles that are enunciated by the Supreme Court in the patent area?
It's funny because some of the judges are more conservative and say, well, if the Supreme Court said anything close to X, then the answer has to be X, and some are not. And I do think that there were times when the Federal Circuit tried to say, okay, well, the Supreme Court told us that this is the standard, but then we're going to say what we can have a different standard of review with respect to this topic so that then we can reverse more easily. And the Supreme Court finally, because of some loud voices like mine, finally said, no. If it's a deferential standard of review, that's exactly what it's supposed to be. So I think that while the Federal Circuit does have a role in trying to interpret what the Supreme Court has said, there are sometimes you just can't get around it, or sometimes when the Supreme Court just hits you back enough times. I mean, I've heard people say that our court could do more in the 101 space. But I frankly agree with most of my colleagues that the Supreme Court has locked us in many areas, in many ways. And we have some dissents, and there are some of us who think we could push the envelope a little bit more, but we keep begging the Supreme Court to revisit this topic. Have you ever seen a court of appeals where every single active judge asks for the Supreme Court to review a topic and the Supreme Court says no? I mean, it's unheard of. But that's what happened, in the 101 space and with respect to medical and diagnostics. So I think that there is a role, as there always is, to say that the Supreme Court really didn't mean everything it said. But it depends on which topic area you're talking about. I wrote an opinion that early on that said eBay did not mean to go as far as it has been interpreted to mean. It did not mean to swing the pendulum the opposite direction. And most of the district court judges say, we hear you, we don't necessarily trust you, because we just think that ultimately if we grant an injunction, it'll get reversed. I think it's getting a little better, but not much.
Just to follow up on that specific point regarding the trouble with 101, they're not listening to all sitting judges begging for more guidance. Do you think that's a result of having a court of exclusive jurisdiction and not having a diversity of views from different courts, and therefore a conflict of opinions that the Supreme Court can potentially resolve? The broader question is, what, to the extent you're comfortable saying, how has the quote experiment worked of having a court of exclusive jurisdiction on such an important issue? There are lots of other complex issues, antitrust, you mentioned copyright, land management, all sorts of things where this hasn't happened. So overall, now that you're about to leave, how has the experiment worked? and with this example specifically on 101?
Well, first of all, the other topic areas you mentioned where they percolate up through the different courts of appeals, unlike patents or perhaps copyrights, it does not create the problem that Congress saw when it created the Federal Circuit, which is that stakeholders had no idea whether they were going to have a valid patent in one part of the country but not in the other part of the country, and that whether their patent would be infringed in one part of the country but not another part of the country. And as technology was getting to the point where businesses wanted to operate on a countrywide basis, and at the time the Supreme Court couldn't have cared less about patent issues, they needed the uniformity, or at least everybody to go one place, so that if a patent's valid, it's valid throughout the whole country. And I still think that makes sense. I think it makes absolute sense. And while I understand there are a lot of other complex issues, they don't affect stakeholders on the nationwide basis as directly as do the patent rights and patent issues. So I think that it has worked. I think one of the problems is, and he doesn't hide it, John Roberts hates what he considers to be a specialized court. Yes, the Federal Circuit is different because it's based on topic areas rather than geography, and one of those topic areas happens to be patents. But it's not a specialized court in the sense of the courts in other countries where a lot of non-lawyers are actually participating in the judicial decision-making, for instance. But I think John Roberts doesn't see that, and he has always been antithetical to the Federal Circuit. And as a result, I think that there are a lot of decisions where the Federal Circuit gets reversed when it really could fairly have been affirmed. And so that's a problem. To the extent the experiment's not working, it's because we have a Supreme Court who didn't like the idea that Congress did the experiment, and so that's a bit of a problem. But I do think it's working, and I reject these calls for sending it back out to all the other circuits, or creating some system where 4 or 5 different circuits maybe get it. The reality is that these issues are complex. At least you've got a body of people who are spending a lot of time analyzing them. You've got a vast cadre of very talented, experienced law clerks who can assist in analyzing them. And so I even though I'm leaving, I still am a believer in the Federal Circuit.
Great.
One last question. Bo, goes to you.
It's the last one. All right.
Well,
That's
yeah, our
pressure.
time.
That's a little
Christina, is that
pressure
right?
now.
Our time is, yes.
Just a disclaimer, non-lawyer. So, but I'm curious, just by being in this field, starting out as an engineer, moving into economics, the idea of inventing something going on in someone's head, and then it's written down in a rather complicated techno-legal jargon, which then a modest amount of effort is put into writing that down, and a modest amount of effort is put into examining it at the patent office. Sorry. But if it turns out to be valuable, a lot of effort is put on by the other side to try to get rid of it. And because it's language, and people are good at arguing, making arguments, right? That it seems that there's an asymmetry there. And now that we have the PTAB and you have these kind of serial IPRs and all these different times that you get like a bite, keep getting bites at the apple, it would seem that anything as almost intrinsically vague, like a patent, if you have enough smart people going after it time and time again, it just can't survive. Just like with double jeopardy, if you got tried over and over again, eventually you'd be guilty, right?
I can't disagree with anything that you've said, really. I've actually said that I don't understand why we're putting so much money into the back end of getting rid of patents where businesses have been built on the fact that the government issued those patents, and not spending as much time, effort, and money on the front end of making sure that the patents that we issue are good in the first place. So I completely agree with that concern, and I think that there have been efforts at the PTO to focus on the front end more, and I think that will continue. But I think I completely agree with you, and I do also have a real problem with the serial attacks. In Europe, you get You get a year to attack, and then it's over. And then they get to move on, but for some, and then your burden is very heavy at the courts to try to get rid of that patent. So the notion that you could keep coming back over and over and over, and different parties without any even real standing or interest can just attack the patent over and over is to me a very bad choice. It was a bad choice in the AIA, but it wasn't my choice.
All right, well, the time went by really quickly, as we knew it would. But let's thank Judge O'Malley for coming in and speaking with us today.
Thank you for having me.
And so that concludes our conference. I was going to stand at the podium, but I think I'll just sit here. Just want to make a few thanks. Again, on the back of our program, we have our sponsors. As many of you know, we couldn't do these programs without our sponsors. And our sponsors also help us, not just financially, but also with a lot of their time. They help us to understand the issues confronting the industry that we're looking at any given time. As you know, the center covers not just information technology, but also biopharma, copyright, pretty much anywhere where IP crops up. So again, we're really appreciative of all the sponsors we have. And again, not just financially, but with the information they give us on what's going on in the industry. And then my final thanks have to, of course, be to the phenomenal team we have here. And so I just want to take a moment to thank each of them. We have Joshua Kresh. Joshua, stand up. Our managing director, who has just done a wonderful job. He was our COVID hire. And now as we're coming back into the real world, you can all meet him, see him in person. Next is Christina Pietro, our director of operations. Really, just those of you who have been with us for a long time know Christina, and she really keeps everything running. You were about to leave, weren't you? And last but not least is Mary Claire Durrell, who came on, I guess a couple of years ago now. And she has just been phenomenal and gave some much needed help to Christina, who was doing all these tasks before that. And now Mary Claire has been able to step in and do quite a lot. So thank you all, the great team, and to the university and to the Antonin Scalia Law School that allows us to do all these things. With that, thank you all for attending and your great comments to all of our moderators and panelists. Have an excellent rest of your day.